Hey everybody, we're back in the Shanty. I love Michigan. Don't you love Michigan? I love Michigan. Saturday it was 80. I got sunburned cutting their ass. Today it's winter. I love Michigan. Anyway, last week, the weather is relevant. How here? I don't know, other than I suppose the fact that it was 80 on Saturday is an indication that we are turning a corner and spring is coming. And last week I was at one of my clients that happens to be at college, and they were getting ready for graduation. And getting ready for graduation got me thinking about internships. Don't ask me why it got me thinking about internships. Those of you that know me know that my mind, to the extent that it works at all anymore, works in incredibly weird and funky employment lawyer ways, but it did get me thinking about internships. And with the HR seminar coming up and us talking about the Great Resignation, the thought of internships in my little brain got rattling around up there. And it occurred to me that we haven't talked in a long, long time about when an intern has to be paid and when they don't have to be paid. As a matter of fact, the last time I did anything on it was way back when we were doing a newsletter. Remember newsletters? And before the current guidance from the Department of Labor had been published. So when does an intern have to be paid? When are they an intern and when are they an employee? That's the question that we're going to discuss today. A couple things you need to know about this question. The question arises in the context of the Fair Labor Standards Act. When is a person an employee under the Fair Labor Standards Act? When are they not? And that determination is based on when the individual is an employee. Are they an employee? If they're an employee, unless they fall into one of the exemptions, they're entitled to the minimum wage and overtime. And if they're not an employee, they might not have to be paid at all. For example, volunteers. Interns kind of fall into that gray area. Now, the other thing you need to remember is this. Just because you call somebody an intern, just because they agree to be an intern, doesn't mean they're an intern. They might still be an employee. The key you have to remember here is, as you all probably know by now, under the Fair Labor Standards Act, an individual, a person, employee, whatever you want to call them, cannot waive their rights under the Fair Labor Standards Act unless a judge or the Department of Labor approves that waiver. So even if you've got an agreement with somebody that says, I will work for you and do these things, and you don't have to pay me, that agreement's not valid under the law if you are a for-profit enterprise. Now, there's different rules for nonprofits and for state and local governments. And I'm going to read to you a minute from fact sheet number 71, issued by the United States Department of Labor Wage Hour Division, which is entitled Internship Programs under the Fair Labor Standards Act. This was updated in January of 2018, so it is a fairly recent publication. There's a footnote that says, the FLSA exempts certain people who volunteer to perform services for a state or local government agency or who volunteer for humanitarian purposes for nonprofit food banks. Very specific there, isn't it? Nonprofit food banks. But the footnote goes on to say, the Wage Hour Division also recognizes an exception for individuals who volunteer their time freely and without anticipation of compensation for religious, charitable, civic, or humanitarian purposes to non-profit organizations. Unpaid internships for public sector and nonprofit charitable organizations where the intern volunteers without expectation of compensation are generally permissible. So, if you're a government agency or if you're a if you're a nonprofit, you can have volunteers, which means you can have quote-unquote interns, and you don't have to pay them as long as the person knowingly volunteers. The fact sheet goes on to say, the FLSA requires, quote, for-profit, end quote, employers to pay employees for their work. Interns and students, however, may not be employees, quote-unquote, under the FLSA, in which case the FLSA does not require compensation for their work. Well, when are they employees and when are they not? If they can't waive their rights, if you can't just come to an agreement, when is an individual an employee and when aren't they an employee? and therefore entitled to be paid or not be paid. Well, there's a test. And it's kind of expanded a little and contracted over the years. It used to be 6 factors. Now it's 7. And it revolves around what the FLSA calls the primary beneficiary test to determine whether an intern is a student, in fact, or an employee under the FLSA. All right? Now, what the wage hour division is focusing on here, and what they focus on a lot of this stuff, they do this with independent contractors too. And the independent contractor employee juxtaposition is they look at the economic reality of the relationship between the worker and the employer to determine if the worker is an employee under the FLSA and therefore entitled to be paid at least the minimum wage and overtime. Which party, they want to know, is the, quote, primary beneficiary of the relationship. Who benefits the most? Cicero said that. Cui bono, who benefits? It's kind of follow the money. How's that Latin in a Shanty podcast? Come on, that's pretty impressive, don't you think? I probably got it completely wrong, but what the heck? So, what the wage hour division does in this case is they say that we're going to go look at what all the courts have done, and we're going to come up with guidance for when an individual is an intern and when they're not an intern, when they're an employee and when they're not an employee. And we're going to use this 7-factor test. Now, before we get all excited and say, oh, cool, that's going to make it abundantly clear, the FLSA also says this: the courts have described the primary beneficiary test as a flexible test, and no single factor is determinative. Accordingly, whether an intern or student is an employee under the FLSA necessarily depends on the unique circumstances of each case. Okay. So that means we're going to give you this test, but we're not going to tell you which one of these things is the most important and which is the least important. And you have to look at the totality of the circumstances. In other words, take these things and make an educated guess about when somebody is an intern and when they're an employee. And if you get it wrong and don't pay your interns, of course, you're subjected to liability under the statute and maybe some liquidated damages under the statute and maybe some penalties under the statute and stuff like that. All right, so what are these 7 factors? Now, let me give them to you. The first factor is this: the extent to which the intern and the employer clearly understand that there is no expectation of compensation. Any promise of compensation, express or implied, suggests that the intern is an employee and vice versa. So I just got done telling you an employee couldn't waive their rights under the statute, but the very first test is, did the individual, did the worker, did the student expect to be paid? Did you promise to pay them? If you did, they're an employee. If you didn't, maybe they're an intern, all right? But that's where we start, all right? So they've got, in other words, the intern has to come into this with the reasonable expectation that they're not going to get paid. Otherwise, we lose right away. Test number 2. The extent to which the internship provides training that would be similar to that which would be given in an educational environment, including the clinical and other hands-on training provided by educational institutions. So, is the intern learning how to do something like they might learn it in college? All right? Are they learning, or are they just getting coffee and making copies for you? Because if they're just getting coffee and making copies for you, they're not learning something like they would in college. Now, that places a burden on you, and that goes back to the old test. The old test actually used to say, who benefits, the employer or the employee? If the employer is benefiting from the intern's work, they're probably an employee and not an intern. Test number 3. The extent to which the internship is tied to the intern's formal educational program by integrated coursework or the receipt of academic credit. Is the intern getting college credit for doing what they're doing? If they're not, that would lean toward an employee relationship. If they are, that would lean toward an internship. A number of years ago, during one of the economic crises we were having, I remember a very famous guy who owns a basketball team and is a dot-com bazillionaire and owns a basketball team down in Texas saying, if I was out of a job, I would just go off and get an unpaid internship and sell myself to the company that I was doing the unpaid internship for. Well, that just goes to show you that owning a basketball team and being a dot-com billionaire doesn't necessarily mean that you know the law, because you can't just go do that. this test would indicate that you have to do it in the context of actual school work, that it's integrated into your academic program. In other words, that an internship is a required part of the program, right? Test number 4, the extent to which the internship accommodates the intern's academic commitments by corresponding to the academic calendar. What does that mean? I don't know what that means. I assume that means that the internship works around the kid's school schedule, which means if you're doing something in the summer, you should probably be okay. 5, the extent to which the internship's duration is limited to the period in which the internship provides the intern with beneficial learning. In other words, once you've graduated, you're probably not getting beneficial learning in the context of your academic program. 6, the extent to which the intern's work complements rather than displaces the work of paid employees while providing significant educational benefit to the intern. This one comes like right out of the old test before they changed it, all right? Who's benefiting? Cui bono, who's benefiting? If you're getting all of the benefit from the intern because they're getting coffee and making copies and filing and the intern isn't really learning anything, the intern is displacing a regular employee who would have to do those things, then it's an employment relationship and not an internship relationship, a learning relationship. And test number 7, the last one, the extent to which the intern and the employer understand that the internship is conducted without entitlement to a paid job at the conclusion of the internship. In other words, if you're coming to us and at the end of this, if you do a good job, you will get a job like Warner Norcross and Judd Summer Associates, who we pay, by the way, then you're not an intern. This is like a probationary period or something like that. But if there is no expectation of a job, if you're just in this for the educational benefit, then it might be an internship. So those are all the things you need to consider. And I know we're desperate for employees, and we're desperate for money, and we're desperate for budget in a lot of cases. But remember, you can't just call somebody an intern and not pay them. You might have to pay them. Now, all you have to pay them is the minimum wage and overtime if they work more than 40 in a work week. So it's not like you have to pay them thousands of dollars a week or put them on a salary or make them exempt or any of those things. But before you go off and do an unpaid internship, you might want to call us and give us a ring because you're going to want to make sure that you meet this test before you bring somebody in who's not getting paid, because the penalties can be fairly extensive. Great talking to you again. Hope to see you all I think it's next week, maybe 2 weeks. I can't remember when it is, at our HR seminar, where I'm going to be on a panel talking about the Great Resignation, and we're going to have some other great topics for you. See y'all soon.